Any mention?
Yes.
May it please your Lordship. Lordship, I beg to mention item number 5. In this matter, you have heard both the petitioner and respondent at length, so we have to file our bullet points here, Lordship. So I pray, Lordship, to 1 week's time,
Who
Lordship.
is the other side?
Nitin.
Have you informed them?
I'll inform him, Your Lordship. I'll
You
inform
will
the
inform and
agent.
you see,
No,
prior information is one thing. It should not be something
Lordship,
like
I
that.
was-
That subjection is reached a subsequent stage.
Yes. I was looking for them, but I didn't see any.
You have the other way to contact us. Anyway, just one prayer made on behalf of the petitioner. Further 1 week's time is granted for submission of bullet points. It was earlier order. What was the order?
Lordship,
Earlier order required you to submit
the bullet points.
bullet points of argument, isn't it? Okay.
Highly obliged.
But you just say it on prayer made by so and so. That's further 1 week's time is granted for submission of bullet points of argument. Yes. Okay.
Highly obliged.
Lordship, I beg to make a mention of item number 6.
Item number 6.
Lordship.
Yes. What happened?
I'm praying for further 2 weeks of time, Lordship.
Wait, what for? What for you keep on
Senior.
asking time in these matters?
Our senior is not available, Lordship, today.
You cannot be dependent for every matter on senior when senior is not free. It has become a problem. Yes.
No objection, Your Lord.
Just say. Mention has been made on behalf of the petitioner to adjourn the matter.
Lordship, similar prayer for item number 8.
Wait, let the court pass orders. Mention is, prayer has been made on behalf of the petitioner to adjourn the matter on the ground of non-availability under senior counsel. Appearing for the petitioner. Start. The learned G appearing for the state has no objection. Prayer allowed. List after 2 weeks. Yes.
Lordship, similar prayer for item number 8 and 11.
Item number 8 you are appearing for?
The petitioner, Lordship.
Item 8.
Lordship.
Who is the respondent here?
I'll inform them, Lordship.
Item number 8. You're right. Same order like before. 11 is 11 you are respondent.
11 this one.
Item 11 under petition.
11 they are respondent, isn't it? So,
I have no objection, Your Lordship, but there's an interim order.
11 is just on prayer made on behalf of the respondent. This is matter. After 2 weeks. Interim order passed earlier. It's interim order in the same.
It's in the miss case
In
only.
this case, you just say like before. Please tell them so and so. Alright.
Highly obliged, Your Lordship.
May please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 9, Your Lordship.
Yes.
Lordship, I'm praying that this matter may come up after 2 weeks, Your Lordship.
My Lord, if next week, my Lord, because
Do you expect it will be taken up in the next week? Just do not get the matter listed just for the purpose of.
no, my Lord, the problem is, my Lord, this the respondent number 2, my Lord,
Yes.
he is due to retire, my Lord.
You say it at the earlier occasion, but then there is no interim order in this case.
My Lord, there is no, but
Now
He's due
rest
to
is
retire only for that
rest
year.
is on your understanding.
My lord.
Until and unless there is an interim order,
absolutely, my Lord.
the pendency should not create a bar for error.
Absolutely, my Lord. That is there, my Lord.
The prayer made in behalf. Prayer made by Miss Captain Learned Counsel. Behalf of Dr. Mayan Mojika representing the petitioner. This is matter after 2 weeks. Yes.
Much obliged.
Your Lordship, I beg to mention item number 7.
Item number 7.
Yes, Lordship.
You are mentioning on behalf of?
Jawai Municipal Board, Your Lordship.
Is the respondent number? What is the respondent number?
Respondent number 7.
What is this?
This is the
Service
pay
matter.
parity matter, Your Lordship. Pay parity.
Pay parity. Service matter.
Yes, Your Lordship.
Pending from last 6 years.
No objection, Your Lordship.
2 weeks time, Your Lordship.
And prayer made on behalf of so and so. Not objected to by and counsel appearing for the petition. This chapter. The state is also a party. 2 weeks.
Yes, Lordship.
Much obliged, Your Lordship.
Daily cause list, item number 1.
Yes.
Lord, this is that matter where the respondent had expired before the institution of this
You have
revision
to file
application.
an objection. It is pending for filing.
Lord,
of objection.
I won't really raise any objection. I've just
That is what you see. That was a technical.
yes, no,
objection
I'll
raised
just
by
point
you.
out. It says it is not maintainable, but at the same time, the Honorable Supreme Court has said it can be treated as an application of the Order 1 Rule 10. So, in view of that, this
Objection
may
is
be treated.
purely technical. And the more particularly this substitution is allowed in the trial court.
Yes.
Yes, that
Lordship.
is allowed. That's allowed.
What remains?
No, so in this judgment, it says it is not maintainable. It can be treated as an application for implement.
You want them to withdraw this and file another
No,
application?
I'm saying it can be treated as one.
Okay.
That's all.
But then we are not doing it. We will simply allow it. Since. Yes. Or you want us to wait for your senior?
Oh, no, Your Lordship.
Court is going to reject the application. Yes. Heard. So and so on the counsel for the petition. Mr. Shan, you are representing all the.
No, Your Lordship. I'm
There's only once. For
What role state has here?
performer.
Performer respondent, Your Lordship, the state.
Okay. Had Mr. So and so for so and so. Mr. Shan for so and so. For respondent opposite party, you are.
I am for one.
Okay, Mr. So and so for the applicant, Mr. Shen for opposite party number 1, and MS ID for performer opposite party number 2 and 3. Paragraph. This is an application for. You can sit down. Please. Substitution. Now, see your prayer. What is this? Opposite party above be substituted as plaintiff in the side pending civil revision. Where is the plaintiff in the civil petition? What is this? What is this prayer?
Lordship, in the lower court, the opposite number 1 is the plaintiff, Your Lordship.
Party may be plaintiff before the lower court, but not
Yes.
plaintiff before here in this court is.
Yes, Your Lordship.
Then he's what here?
Oh, here is the respondent number 1.
But that has. I don't know. You should have checked it. What is it? It's an application for substitution. Huh? Respondent number 1 in civil division petition number 18 of 2025 by the opposite party number 1 herein. Is it correct, Mr. Shen?
As
They want the original respondent in the civil division to be substituted by opposite party number 1 here.
yes, correct.
Correct?
Correct.
You didn't by opposite party number 1. Stop. It is stated that the original respondent of the civil division who was plaintiff in title suit number 314 within bracket T of 2013 has passed away. On which date?
20th of July 2025.
It is also submitted that pursuant to the demise of the respondent number 1, original respondent number 1 stop plaintiff, the opposite party number 1 herein has been substituted in place of the deceased in title suit number 314 of 2013. Stop. Paragraph. The Honour Counsel appearing for the opposite parties has no objection to the prayer made in this application. Stop. Paragraph. Resultantly, the application is allowed. The opposite party number 1 herein is substituted in place of the respondent number 1 in CRP number 18 of 2025. Stop. The applicant shall take appropriate step to modify the cost title of the CRP number so and so accordingly. Stop. Disposed of application not disposed.
Highly obliged, Your Lordship.
Item number 2.
Please, Your Lordship. Lordship, service affidavit has been filed. Lordship.
Wait for the file. You are in hurry,
No,
but to go somewhere. Yes.
service affidavit has been filed, Lordship. So the matter may be fixed for hearing.
Service affidavit has been filed.
Yes.
In respect of respondent number
3.
anyone appearing for respondent number 3,
Not yet, Your Lordship.
you are representing
For the
state.
state, Your Lordship.
And what is the matter here?
This is a revision petition also
Against conviction,
against
Yes, Your
conviction.
Lordship.
against confirmation of conviction by appellate court.
Yes,
That is how revision has come, isn't it?
yes.
Paper book is prepared.
Yes,
Is needed. Okay. It is submitted by the Honour Counsel for the petitioner that an affidavit showing the factum of delivery of notice upon the respondent number 3 has been filed. Stop. However, there is no appearance on behalf of the said respondent when the matter is called up. Stop. There is no requirement of passing any order saying ex parte, isn't it?
No, Your Lordship.
Yes, sir. Then just say the Honour Counsel appearing for the parties submit that the paper book has been prepared in this matter. And the matter is ready for hearing. So, spread for when shall we
3 weeks, Your Lordship.
3 weeks.
list? See next for hearing. Yes.
Obliged.
Much obliged, Your Lordship.
Item number 3.
Yes.
May it please Your Lordship, in this matter the respondents have already filed their objection. Let this matter be posted for hearing, Your Lordship.
This is a review application.
Yes, Your Lordship.
What order is sought to be reviewed here? We cannot dispose it now. Dispose it off now.
Your Lordship, the senior counsel will need to be here, Your Lordship.
What is your prayer? Which order you want to be reviewed? Oh, there's an application for condemnation of delay.
Your Lordship.
And what is the period of delay?
423 days, Your Lordship.
So we'll condone it.
Your Lordship, we've already filed our objection. We will not.
You filed your objection.
Yes, Your Lordship.
So we'll consider your objection. You want senior counsel to be present?
Yes, Your Lordship.
Okay.
After 2 weeks, Your Lordship.
Why 2 weeks? Just it is submitted. That objection on behalf of the respondent has been filed against the prayer for condemnation of delay. Stop. Paragraph as prayed for by the parties. List after 2 weeks for hearing.
Lordship.
But we do not have to get it in the hearing list for this thing. List after 2 weeks. That is okay. It can be disposed of in the order column.
Yes, Your Lordship.
For disposing condemnation
Yes.
application, it is not needed that it should come up in the these things. As per the party list after 2 weeks.
Item number 4.
Yes.
May it please Your Lordship. Your Lordship, on the last occasion we have filed a wakalatnama,
Okay.
and today it's listed for hearing. However, the counsels are not, due to some personal difficulties, they couldn't be here.
There's no problem in it. We'll list it for hearing. It has not been posted for hearing yet.
Okay, sir.
Isn't it?
Yes, sir.
So,
If Your Lordship.
service is complete.
Yes, Your Lordship.
All the respondents are represented.
Yes, Your Lordship.
Okay.
If Your
So,
Lordship could kindly get this matter listed on second or third.
we do not know. Just we'll see. It is dependent upon the convenience of the thing. We'll just we'll list it after 3 weeks then.
Okay.
Is it?
Highly
3 weeks will be all right.
Your
Isn't
Lordship.
it? Yes.
Highly obliged,
Learned
Your
counsel.
Lordship.
Wait. Let the court pass order.
Yes, Your Lordship.
The learned counsel letting the parties submit that the matter is ready for hearing. Stop. Let's wait for list for hearing after 3 weeks. Yes.
Highly obliged, Your Lordship.
Supplementary cost list. Item number 1.
Yes, Mr. Shen.
Yesterday I had paused at the point where I had taken your lordship to the order passed in the second application. I had taken your lordship to the second order, the second application to show the reasons that had been cited by the respondent for moving the application. May I just refresh lordship's memory by taking your lordship to page 74. First application they said inadvertence. Inadvertence was the cause for the omission to mention that
That
name.
is what the provision says.
Yes, and that is what they had cited. Court found this was not sufficient because there was nothing more beyond that. So court rejected it. Then they filed a second application, which is at page 74. And my lord, what is also relevant is the date of filing. So the second one was filed on 28th of November, 2024.
So it was filed on 28 November 2024.
Yes, I'll just go over the dates again, my lord. The first application was filed on 18th of May 2023. It was dismissed on 4th of September 2023.
Just a minute, Rastro.
My lord.
Dismissed on
So first was filed on 18th of May 2023, dismissed on 4th of September 2023.
Acha. Okay.
My lord. Second application was filed on 28th of November 2024.
Yes.
And it was allowed by an order dated 21st of July 2020.
That is the impugned order.
Impugned order, my lord. So if your lordship will take that second application at page 74,
You can leave one of it. Yes.
you must first see the cause title. They've invoked the same provision
Yes.
in respect of the same witness, but here they say it's been filed for allowing the plaintiff to adduce additional witnesses of Sri Ram Gopal Agarwal by replacing Hari Krishan Agarwal. The relevant part is at page 75, para 4. This is the explanation.
Okay.
This reads that the petitioner says that meanwhile the brother-in-law of the plaintiff and brother of plaintiff's husband so-and-so, who was named as a witness in the original list of witnesses filed by the plaintiff on so-and-so, expired on 21/9/2023, and as such, late Hari Krishna Agarwal has to be dropped from the said list of witnesses, and in his place, Sri Ram Gopal Agarwal is now required to be adduced and replaced.
In this case, otherwise, how many witnesses are there?
I think about 4, my lord. In total, there are 5. Sorry, 4. 4, and including the plaintiff, 5 witnesses. 5 including the plaintiff. So, my lords, this is the basis that they have for this application, that somebody who was already featured in that original list has expired and they need to replace him. Some sort of substitution. That's what they say in the cost title as well. Then they give the reasons why there was a delay. They say the bereavement and the customs went on for about a year.
Is there any provision,
My lord.
which allows substitution of witness?
No, it doesn't. That's what. It doesn't. So, one of the issues is, my lord, I am saying that it is barred by the principles of res judicata. Now, res judicata, there are 3 requirements.
Because
One,
there is earlier rejection.
yes. So, there are 3 requirements. One, the parties have to be same or litigating under the same title. Here, there is no dispute, the parties are the same. There's only one sole plaintiff and one sole defendant. Then the field of controversy or the subject matter has to be the same. Here, in my mind, as far as I understand, the field of controversy is the same. It's the question of introducing one particular witness. It's not there's a different witness altogether. This is one particular witness. And the same thing is omission. What is the reason for the omission of the person? Now, that has already been done. Now, the second time around when they move the application, they give a completely new dimension to this by saying, now we want to perform a substitution, which is not permissible. So, I would understand the field of controversy is identical because they are trying to bring the same witness.
Now, what happens in a case?
My lord.
Just do not confine to the facts and situation of this case. A situation may come and the additional witness
Yes.
is required to be brought to the court.
My lord.
What happens? They will have to go by the same rigor of order
Correct.
16, rule 3.
Correct.
Is there any other provision in law which allows?
Not to my knowledge, my lord. This is the only chapter which
If it
deals
is not
with.
in your knowledge, then you have to say that there is no such provision, isn't it?
Not to my knowledge. Depends on what my learned senior may say.
Definitely, we'll say it.
So, not to my knowledge, there is no such provision because this chapter order 16
No,
deals with
the
witnesses.
query which court is making may not be very relevant for the purpose of decision.
I understand.
But then, like say, supposing not in the identical situation which we are dealing with right now,
Lordship.
a situation may arise where an additional witness is required. Deposition of a person is needed. Okay, then what happens? The application has to be filed under order 16 rule 3.
And that is exactly what happened in the first time. In the
That
first
is that
instance.
is the only provision available in CPC.
Absolutely. That is why at the first instance, this particular gentleman was not mentioned in the list. He was the additional witness. So they invoked sub rule 3 and they said we have omitted for inadvertent reasons to mention his name in the original list. So therefore we want to bring him as an additional witness. Right, wrong, that application was rejected. Second time around, again they have to do the same thing. They'll have to indicate the reasons for the omission. This time they say no, we want to perform a substitution. That I don't understand. That is completely foreign to order 16. So that's the only issue. So now there are 3 requirements. One, parties have to be the same. The controversy has to be the same.
It is unlike right to sue, which may
Yes. Yes, exactly. Witness has no right in a
after
case.
demise of a particular party.
Yes,
in a
my
case.
lord. Witness has no right to
There
sue.
cannot be such proposition.
Absolutely. And it's not I don't even know what to say as far as this particular plea is concerned. That he is expired, I want to replace and substitute him. So that's one. The third requirement is that the decision in the former proceeding or the former suit has to be conclusive and binding. That's the case here. It's conclusive because till date it has not been set aside or challenged before any court. So we meet all three requirements for the purpose of the application of the doctrine of res judicata. So given this application, we filed a show cause, particularly raising the point of res judicata, and well, it's the impugned order, if my lords will find, at page 10. This is the order dated 21st of July. Now, here, my lords, the court travels beyond the pleadings. Page 10, it starts from page 11.
Is it the same court which
Same
passed the
court,
earlier
same
order?
court. It's in the main suit itself. Same court.
By the same presiding
No, no,
officer?
not the same presiding officer. Different presiding officer.
Yes.
So, well, it starts at page 11.
Okay.
Here the court records the submissions of the parties. And, my lord, we'll see page 13, para 11, where the court records my plea of res judicata. Let's have it.
Yes.
Learned counsel for the opposite party submitted that the application is barred by the principles of res judicata and therefore liable to be dismissed at the threshold itself. Learned counsel for the opposite party submitted that the instant application is severely delayed and barred by the principles of waiver, acquiescence and estoppel. Learned counsel for the opposite party submitted that the present application filed by the petitioner is not maintainable as the Honourable Court has already rejected a similar petition, which is petition number so-and-so, wide order dated so-and-so, on the ground that there was no sufficient cause shown for the omission of the name of late so-and-so in the original list of witnesses. Learned counsel for the opposite party has placed reliance on the judgment of so-and-so, which states that it is now well settled that the principles of res judicata applies in different stages of the same proceeding. And the court goes on to record further that it is well settled that the principles of res judicata can be invoked not only in a separate subsequent proceedings, they also get attracted in subsequent stages of the same proceeding. Once an order made in the course of a proceeding becomes final, it will be binding at the subsequent stage of that proceeding. Then, my lord.
Otherwise, it also comes as a miscellaneous case, isn't it?
Absolutely.
And the proposition of law in CPC has to be applied to this case also.
Yes.
142, 141.
141. My lord. So this goes on. Then please turn to page 15. This is a judgment that was relied upon by the respondent.
Yes.
Para 16, my lord.
Yes.
This is the judgment that I was referring to. May I just read this, my lord?
Yes.
In Mangiram versus so-and-so, the Honorable Supreme Court of India observed as follows. If the requirements of these provisions are conjointly read and properly analysed, it clearly transpires that the obligation to supply the list.
It refers to which provision? The requirement of
Order
these provisions?
16.1 and 1A. As well as the gist of the evidence of each witnesses whose name is entered in the list has to be carried out in respect of those witnesses for procuring whose attendance the party needs the assistance of the court. This is with regard to Rule 1. When a summons is issued by the court for procuring the presence of a witness, it has certain consequences in law. If the summons is served and the person served fails to comply with the same, certain consequences in law ensue as provided in Rule 10 of Order 16. The consequence is that where the witness summoned earlier, either to give evidence or to produce documents, fails to attend or produce the documents in compliance with the summons, the court, on being satisfied of the services provided therein and is further satisfied that the person has without lawful excuse failed to honour the summons, the court may issue a proclamation requiring him to attend, to give evidence, to produce the document at the time and place to be named
We are not
therein.
concerned with all those things.
We are not concerned. Please come down. 8th line from the bottom. It begins with there, however, remains an area.
Yes.
There, however, remains an area where if the party to a proceeding does not desire the assistance of the court for procuring the presence of a witness, obviously the party can produce such witness on the date of hearing, and the court cannot decline to examine the witness unless the court proposes to act under proviso to subsection 1 of so-and-so, which enables the court, for reasons to be recorded in writing, to refuse to examine any witness or witnesses if it is of the opinion that the evidence of such...
Just a minute. The court cannot, because there is a provision of section 1 of section...
No, this is with regard to the subject matter, REP Act. Yes. This originally was an election petition.
Okay.
Is of the opinion that the evidence of such witness or, I'll turn to the next page, my lord, or witnesses is not material for the decision of the petition, or that the party tendering such witness or witnesses is doing so on frivolous grounds or with a view to delay the proceedings. It is therefore unquestionably transpires that the obligation to supply the witness list of witnesses within the time prescribed under 1 of Rule 1 of Order 16 is in respect of witnesses to procure whose presence the assistance of the court is necessary. Then please see the next page, page 18, that first paragraph.
What is the relevancy of those part which you have read out just now?
So they draw a distinction between Rule 1 and Rule 1A. They say Rule 1 is only with regard to witnesses where you need the assistance of the court, and for 1A you don't need any documents, you don't need to mention
But
list.
the list of witnesses needed, isn't it?
Not required. Even for 1A, a list of witnesses is not required. May I just go on to read this paragraph, my lord? It will be further clear.
Yes. Okay. Yes.
I'll just read from this line. 7th line, my lord.
Okay.
At page 17, and this ought to be so because the court wants to be satisfied about the necessity and relevance of the evidence of such witness whose presence will be procured with the assistance of the court. This not only explains the necessity of setting out the names of witnesses in the list, but also the gist of evidence of such witness. If mere omission to mention the name of witnesses in the list envisaged under Subrule 1 of Rule 1 of Order 16 would enable the court to decline to examine such witnesses, Rule 1A of Order 16 would not have omitted to mention that only those witnesses kept present would be examined whose names are mentioned in the list envisaged in Subrule 1 and who can be produced without the assistance of the court. Viewed from this angle, Rule 1A becomes wholly redundant. It is obligatory upon the party to mention the names of all witnesses irrespective of the fact whether some of them are to be summoned, and even the names of those whom the party desires to produce without the assistance of the court are also required to be mentioned in the list on the plane that they may not be permitted to be examined. Rule 1A would have given a clear legislative exposition in that behalf, and the marginal note of Rule 1A clearly negatives this suggestion. Marginal note of Rule 1A reads as production of witnesses without summons, and the rule proceeds to enable a party to bring any witness to give evidence or to produce documents without applying for summons under Rule 1. If it was implicit in Rule 1A that it is only enables party to examine only those witnesses whose names are mentioned in the list filed under Subrule 1 of Rule 1, whom the party would produce before the court without the assistance of the court, it was not necessary to provide in Rule 1A that the party may bring any witness to give evidence or to produce documents without applying for summons under Rule 1. Rule 1A of Order 16 clearly brings to surface the two situations in which the two rules operate, where a party wants the assistance of the court to procure presence of a witness on being summoned through the court. It is obligatory on the party to file the list with a gist of evidence of witness in the court as directed under Subrule 1 of Rule 1 and make an application and provided under Subrule 2 of Rule 1. But where the party would be in a position to produce its witness without the assistance of the court, it can do so under Rule 1A of Order 16, irrespective of the fact whether the name of such witness is mentioned in the list or not. Save this, the court has no jurisdiction to decline to examine the witness produced by the party and kept present when the evidence of the party is being recorded and is not closed, and the court has no jurisdiction to refuse to examine the witness who is present in the court on the short ground that the name of the witnesses was not mentioned in the list filed under Subrule 1 of Rule 1 of Order 16. So, my lords, in a nutshell, what this says is that one can give a list. Ideally, that list is meant for those people for whose presence assistance is required, but also under Rule 1A, there could be some names whom I have control over and I can bring them in court and they are present in court.
So there is no requirement of disclosure of names prior to bringing them.
There is no requirement, and also if that name is mentioned and he is within my control and I bring him to court, then the court would have to allow me to examine that witness. That's all. Now, interestingly, I'm anticipating they might say his name may not have been there, it is not even required to be there. Now, the only distinction here is that we don't know whether that witness is within your control or not within your control. There is nothing mentioned in their application, in either of their applications.
No, that is okay. But then you see, the 1A says,
My lord.
subject to provision of 16.3.1. Just a minute. Where is that? CPC. 16.
Order 16, Rule 1A.
Rule 1A.
Yes.
Now, if 1A is totally independent,
My lord.
if 1A, Rule 1A is totally independent,
My lord.
other provision of Rule 16,
Yes.
then why it is said there, subject to the provision of Sub-Rule 3 of Rule 1.
Yes.
So,
So what
is
this
meant by
judgment
that?
is now saying, what the judgment says, is that I may have mentioned the name of all the witnesses, including witnesses who are within my control.
Okay.
But for that, there has to be a specific plea. The court is not supposed to know whether these witnesses are within your control or not within your control.
No, but then see, by inserting that part, subject to the provision of Rule 3 of Rule 1,
Yes, my lord.
it may give an application that if any application under Rule 3.1 is rejected,
Lordship.
then that will have a bearing if any subsequent any person is sought to be examined under by exercise of Rule 1A.
My lord, if I have
Say
taken your
supposing
lordship,
the question is that,
my lord.
say supposing you initially try to summon a witness by filing an application under Order 16 Rule, Rule 2, Rule 1, or Rule 3, Rule 3, isn't it? 16.1,
Sub-Rule 3.
Sub-Rule 3.
Yes.
Okay. Now that application is rejected. Can you subsequently bring the same witness saying that he is under control and get him examined under 1A?
In my mind, yes, I think that can be done. To be very fair, it can be done.
Why it is said?
But that wasn't done.
No, but then why this provision starts with the provision subject to the provision of Rule
Because,
Rule 3.1?
so that is reconciled by this judgment, which says that in that list, you could also have featured names of people who are within your control. That's what this is saying. May I just take your lordship to the actual judgment?
No, that is not very clear to this court till now. That's why the 1A starts
Yes,
with the
my lord.
provision of subject to the provision of.
Just kindly have the judgment. That's explained here. Please take page 41, which I have flag marked, para 7 onwards.
No, that is the same paragraph which has been reflected there, is it?
Yes. May I just read again, Willard? Para 7 onwards.
Para 10 is the answer to your lordship's query, my lord.
Yes.
So I'll read para 10. No difficulty, I'll read para 10. Page 43.
Yes.
It is, however, contended. Malus have it?
Yes.
It is, however, contended that Rule 1A is subject to Sub-Rule 3 of Rule 1, and therefore the court must ascertain how far Sub-Rule 3 would carve out an exception to the enabling provision contained in Rule 1A. There is no inner contradiction between Sub-Rule 1 of Rule 1 and Rule 1A of Order 16. Sub-Rule 3 of Order 1 of Rule 1 of Order 16 confers a wider jurisdiction in the court to cater to a situation where the party has failed to name the witness in the list and yet the party is unable to produce him or her on his own under Rule 1A, and in such situation, the party of necessity has to seek the assistance of the court under Sub-Rule 3 to procure the presence of the witness, and the party may, if it is satisfied that the party has sufficient cause for the omission to mention the name of such witness in the list filed under Sub-Rule 1 of Rule 1, still extend its assistance for procuring the presence of such a witness by issuing a summons through the court or otherwise which ordinarily the court would not extend for procuring the attendance of a witness whose name is not shown in the list. Therefore, Sub-Rule 3 of Rule 1 and Rule 1A operate in two different areas and cater to two different situations. The analysis of relevant provisions would clearly bring out the underlying scheme under Order 16, Rule 1 and Rule 1A, and Rule 22 of the High Court rules would not derogate from such scheme. The scheme is that after the court framed issues which gives notice to the parties what facts they have to prove for succeeding in the matter, which notice would enable the parties to determine what evidence, oral and documentary, it would like to lead, the party should file a list of witnesses with the gist of evidence of each witness in the court within the time prescribed by Subrule 1. This advance filing of list is necessary because summoning the witness by the court is a time-consuming process, and to avoid the avoidable delay, an obligation is cast on the party to file a list of witnesses whose presence the party desires to procure with the assistance of the court. But if on the date fixed for recording the evidence, the party is able to keep his witness present despite the fact that the names of the witnesses are not shown in the list filed under Subrule 1 of Rule 1, the party would be entitled to examine these witnesses and to produce documents through the witnesses who are called to produce documents under Rule 1A.
That part is understood. There is no confusion about that.
My lord.
Now, only thing is that rejection of an application under 16
Subrule 3.
Subrule 3. Whether the same person can be again.
That is what I'm saying, my lords. Ultimately, it boils down to the same thing. If you wanted to bring a witness who's within your control, you take recourse to 1A. There's no difficulty. But you are knowingly invoking Subrule 3 and saying that I've omitted to mention his name, etc. Nowhere do you say I'm invoking 1A and this person is within my control.
1A is, we are not at all concerned with 1A.
We're not concerned with 1A.
So
that's all. We're not concerned with 1. No, I'm just trying to explain to your lordships because
okay.
Perhaps this could be one of the...
You see, bringing 1A will create confusion.
No,
here.
I'll tell you lordships why 1A is relevant. Because the court refers to 1A now. Now the court says, I'm allowing because this witness falls under 1A.
See, admittedly, their first application under Subrule 3.
Yes.
Second application also under Subrule 3.
Yes.
So matter is confined to the provisions
Correct.
of Subrule 3.
Correct, madam. But the court gives the reason that he's within the control. Where did the court find this from? There was no pleading.
No, that is not for the court to say. It is for the party to say that is in my control.
Lordship.
It is a party who will say that I have a witness with me
My lord.
who should be examined.
Which is nowhere. That's what I'm saying. On the record, lordship, it's not mentioned anywhere. Now please
That
see.
is not mentioned anywhere in the petition also, isn't
Nowhere it is mentioned. Now please see. I'll just indicate where this is said, my lord.
Say supposing if that be the situation, even if it was the situation,
Lordship.
that yes, they say that yes, witness was in their control.
My
The
lord.
second application, at the time when the second application was taken up and it was considered, and if had it been the contention of the other side that this witness is in our control, you can bring him. Whether court could have allowed it.
In my mind, I think yes.
Then what is the purpose of you see the starting line of the 1A, Rule 1A?
Which is referred to in the other paragraph, my lords, which I was just reading, para 7, 8 and 9.
So persons whose basically application for summoning a witness has been rejected, he can again be examined under 1A.
No, my lord. So that is the issue. He has been rejected, being known as a witness who is not within the control.
Anyway, let us
So
not go-
here the facts are slightly different. Your lordship is asking a broader question, that what would happen whether
See,
1A is
this-
available to
basically
anybody.
The purpose of asking is to clarify the confusion which the court is having in its mind.
My lords. But it's
It is
easier
what-
to...
sometimes asking question clarifies the
Correct,
case.
correct.
Okay.
For right now...
Purpose is them. Court is very much conscious of the fact that 1A is not at all there so far as the pleas of the parties are concerned.
Lordship.
Isn't
Correct.
it? Application is totally under Subrule 3.
Lordship.
Both the applications.
My lord.
That is...
I must also say, lordship will find there's a huge delay in this whole time period. From the dismissal on 4th of September 2023 till the filing, there is a huge delay of more than roughly about 14
What
months.
delay has to do here?
Within that period, I recall, this is again not part of the records, they made an attempt to the court to read Mangiram and say, this person is within my control, I want to bring him, although the witness was not present. So we would like to advance arguments on Mangiram.
How do you establish that before?
No, I'm just saying, this is again outside the records of the case. This is something some attempt was made, but ultimately, they did not take recourse to this provision as well. They made an indication to the court that 1A indicates that I can bring this person, allows me, but they didn't go through with it. Ultimately, what they did, I was under the impression they would file an application under 1A. They did not do so. They filed a similar application invoking Subrule 3 and saying we've omitted to mention so-and-so's name. Now we want to carry out a substitution. So, to my mind, the principles of res judicata will apply. So, therefore, Lordship is right. We need to now confine ourselves only to the two applications. We don't need to go beyond and see what is possible, what may not be possible. Only with regard to these two applications. What are you really asking for? What are your pleadings? Now, please see page 19, my lord. This is the last part of the impugned order. You want to have it? Para 18.
Yes.
Page 19. On examination of the petition filed by the petitioner, it reflects that after the death of late Harikrishna Agarwal, the witness Sri Ram Gopal Agarwal is vital and material for the purpose of proper adjudication of the instant suit. With regard to the contention that allowing Ram Gopal Verma as additional witness would cause undue delay and that the Honorable Court by order dated so-and-so was pleased to reject the prayer to allow the additional witness so-and-so on the ground that there is no sufficient cause for the omission to mention the name of the witnesses in the said list, the provision of law laid down under Rule 1A of Order 16 is very clear and unquestionably transpires that the obligation to supply the list of witnesses within the time period under Subrule 1 of Rule 1 of Order 16 is in respect of witnesses to procure whose presence the assistance of the court is necessary. A conjoint reading of Rule 1A of Order 16 and in light of the decision of the Honorable Apex Court, it clearly transpires that the obligation to supply the list as well as the gist of the evidence of each witness whose name is entered in the list has to be carried out in respect of those witnesses for procuring whose attendance the party needs the assistance of the court. In the suit in hand, the trial of the suit is at the stage of evidence by the plaintiff and the evidence of the plaintiff is not closed. Further, this court is of the opinion that where the bar of furnishing list of witnesses under Rule 1 of Order 16 is for those witnesses whose assistance of the court is required for the purpose of securing their attendance, therefore, where assistance of the court is not required for the purpose of securing the attendance, Rule 1A of Order 16 would be applicable.
See,
Court goes beyond.
You see, 1A is there for the witnesses where assistance of the court is required. So what is the need of passing this order then?
Yes. Exactly. My lords, and most importantly, this application is under Subrule 3. Nowhere do they say that this witness is within my control. The court infers this.
Anyway, okay, let's hear the senior counsel. Or you want to...
Would Lordship require any judgment on this point of res judicata, which is already indicated in this judgment?
Res judicata will definitely... Anyway, there should not be any confusion. Let us see. Let us see if required, we will come back to you.
Lordship.
Yes, sir. You can address us.
My lord, facts are not much in dispute. What my learned friend
Please give your names.
R.K. Agarwal.
Yes.
My learned friend, in his way, put up the entire facts, my lord. I will not repeat that.
No, that is fine.
Except the legal implications of those facts on my case. Now, here the lordship will find, I am not on merit, my lord. Earlier application was filed to include the name of Ram Gopal Agarwal in the list of witnesses. Though there was no prayer to summon the witness, but then purpose was that he may be required to summon the witness, plaintiff may be required to summon the witness. Court declined that prayer. I will put one instance, my lord. Suppose I make an application before the court for withdrawal of my suit with leave to file another suit. Court dismisses my application because leave was not prevailed over the court, that leave will not be granted. Subsequently, I file an application that I simpliciter, I want to withdraw my suit. That application, court has no jurisdiction to decide because it is my right to withdraw the suit without leave to file the fresh suit. Court allows that application. Whether the question of res judicata will apply, my lord, it will never. Because have two ends of the matter. One where I was seeking leave of the court to withdraw the appeal, a suit, that was denied. Another, I simply want to withdraw my suit. And that was allowed by the court.
No, that is, what matters is that whether considered is on merit or not.
My lord?
Whether consideration of the entire matter
yes.
was on merit or not, that is what.
No, I am on the...
can become a basis only where there is a question and decision on merit, by going into the...
Yes. I am on the res judicata issue, my lord. Res judicata, here in fact, res judicata does not apply. I have recent judgment of 2026 Supreme Court in the same case because it was all procedural part. There was no substantive matter to be decided by the court on the merits of the case. What is issue about? What is one denies, other agrees. So here is no issue as such. Here is a procedural part which is no substantive part of the matter to be addressed by the court. It was only procedural matter. So that part may be looked into. There is no issue as such. My learned friend is harping on the issue. Parties are same, everything is same. It is in the two stages of the proceeding also res judicata applies. Suppose my lord, a preliminary issue has been decided by the court on the limitation. And that I don't challenge. Then that issue is final because there is a issue on law and fact that whether the suit is barred by limitation is a preliminary issue. Here there is no preliminary issue as such. It is only a procedural matter, not issue also. So, my lord, what the earlier court says, that I cannot take your name to the list of witnesses for the reason that it could have been filed earlier. Since suit was filed in 17, 18, you filed the list of witnesses. After 7 years, I cannot. All right. That application, if I say that was wrong, I cannot. Because I am yet to challenge that order either by writ petition, what is called revision here, or under section 105 CPC, I can challenge that order while preferring appeal against the final judgment. Supreme Court says that when there is a scope for challenging the interlocutory orders in the final judgment passed against that, if the occasion so arises, if I win the case, I need not go for the appeal in that case. If I lose the suit, I will go for appeal. In that appeal, section 105 is very important, that you can challenge all the interlocutory orders. My lord, may kindly see 105 CPC. Other orders.
Yes.
That's important.
Yes.
Other orders, save as otherwise expressly provided. Why this is given, my lord? Because under order 43 rule 1, there are about 19 orders against which appeal lies. In order 43 rule 1, there are 19 orders like 913, order 2121. So there are about 19 interim order against which appeal lies. This is not that where the appeal lies. Such order is not appealable. Now here, save as otherwise expressly provided, no appeal shall be from any order made by the court in exercise of original or appellate jurisdiction, but where a decree is appealed from, any error, defect or irregularity in any order affecting the decision of the case may be set forth as a ground of objection in the memorandum of appeal. So the Supreme Court says in recent judgment of 2000.
What do we have to do with this here?
My lord?
In which way, what this provision, what bearing this provision has?
Yes, my lord, this provision is bearing for the reason that my learned friend was arguing that the other order, earlier order attained finality. I say earlier order did not attain finality. I had still an scope to challenge that order while preferring appeal against the main judgment under section 105. And this has been addressed by the Honorable Supreme Court by Justice Dipankar Datta in a very recent judgment of 2026 on the same issue, my lord. My lord, may kindly see.
Just a minute. Just a minute.
This is 2026 INSC.
Just a minute. Just a minute.
My lord.
Yes, please.
Now, my lord, we kindly see para 9 of this judgment. Exactly on the same point. Very kindly.
Para 9.
Para 9. Quite apart, such an interlocutory order, rejection of IA number 4, is not independently appealable under section 104, read with order 43 CPC. Here also it is not independently appealable because this does not fall within the series of orders as provided under 43 rule 1. Nevertheless, subsection 1 of section 105 specifically provides that although no appeal lies from such order, where a decree is appealed against, any error, defect or irregularity in an order affecting the decision of the case may be raised as a ground of objection in the memorandum of appeal for facility of understanding. Subsection 1 of section 105 CPC is quoted hereunder. I will not read because I have already read. Now, taking note of the provision, the dismissal of IA by the trial court in suit does not preclude the defendant from questioning the correctness of that order while asserting the final decree passed in the suit. Consequently, it remains open to the defendant to urge before the appellate court that the suit was barred under Order 2, Rule 2, notwithstanding the earlier rejection of the application raising that plea. At this stage, it would be opposite to notice the underlying object of provision akin to Section 105 CPC.
This 105, if you rake these things, but then that you can do it after the disposal of the matter.
Yes, so my lord, here the
So
Supreme
that
Court.
stage we have not reached that stage.
I am. So the Supreme Court says that that order will, my lord, may kindly see another 2 lines. Supreme Court says that such interlocutory orders will not attain finality
That is
because still the appeal can be filed against that order. Otherwise, this order is not appealable.
See, the stage of the matter will assume importance if you are to. Section 105.
I may read, my lord, one para 12 on that issue exactly.
Yes.
At this juncture, it becomes necessary to closely examining the opening words of Section 105 CPC, namely, save as otherwise provided. The said expression is of determinative significance inasmuch as it carves out exception to the general rule that interlocutory orders are not independently appealable but may be assailed in an appeal against the final order. The legislative intent undergirding this phrase is to recognize that where the CPC itself provides a specific mechanism of challenge to certain orders, such orders must be assailed in the manner so prescribed, failing which the right to question them stands foreclosed. So what the court says that if CPC provides us against this order under 43(1) appeal lies, then in that case your right to is foreclosed and that will attain finality. Here my right is not foreclosed, and this was again answered in para 14, my lord.
Your right to appeal, right to assail the order is not.
Assail the order in appeal.
That is a different issue.
No, the Supreme Court says that order has not attained finality. That is what in para 14. The order which I did not assail in jurisdiction or revision.
You are trying to contend that once your right is not closed, the question of
yes.
res judicata will not arise.
Only point, not res judicata. I will come on the res judicata is a different point, my lord. I am on the point as Lordship or he argued attained finality. I am on that point. It never attained finality. What Supreme Court says. I can make the second application also. My lord may kindly see this para 14 is very important.
Yes.
Yes. My lord, earlier part we can leave, but I will read because it may give other signal otherwise. It is needless to point out that interlocutory orders are of various kinds. Some like order of stay, injunction, receiver are designed to preserve the status quo leading the litigation and ensure that the parties might not be prejudiced by the normal delay which the proceeding before the court usually take. They do not in that sense decide any matter on the merits of the controversy in issue in the suit and do not of course put an end to even in part. Such orders are certainly capable of being altered or varied by subsequent application for the same relief, though normally only on proof of a new fact. My lord, here is a new fact. Earlier order was made in sometime in September. I filed the application after a month about, after death of Hari Kishan. There was a new fact. Lordship, I observed the last day, observed that yes, if there was something new fact, definitely it could be considered. Now, the difference from the one just now referred to lies in the fact that they are not directed to maintaining the status quo or to preserve the property pending, but are designed to ensure the just, smooth and orderly, expeditious disposal of the suit. They are interlocutory in the sense that they do not decide any matter in issue arising in the suit. I am on that point that it is not any matter which is arising out of the suit. It is not an issue as such. Lordship may kindly see the issues frame. My learned friend is placed on record the issues. These are not any issues to be addressed by this order. Now, and dealt with by appellate court. In that sense, the refusal of court to permit the defendant to set the clock back does not attain finality. Set the clock back. I am not setting the clock back here in my case. Still, I am developing my argument quite beyond that. That court can set the clock back in the given facts or the new facts if arises. Does not, but what we are concerned with is slightly different, and that is whether the same court is finally bound by that order at later stages so as to preclude its being reconsidered. Even if the rule of res judicata does not apply, it would not follow that on very subsequent day which the suit stands adjourned for further hearing, the petition could be repeated and fresh order sought on the basis of identical facts. Now, The principle that repeated applications based on the same facts and seeking the same relief might be disallowed by the court does not, however, necessarily rest on the principle of res judicata. Thus, if an application for the adjournment of a suit is rejected, a subsequent application for the same purpose, even if based on the same facts, is not barred on the application of any rule of res judicata. My lord, my evidence was closed. I requested the court to reopen my adjournment. That was denied. I asked for adjournment. Court denied my application. Supreme Court said still there is no issue as such decided. For a reason shown, court can still allow you to examine the witnesses, but would be rejected on the same ground on which the original application was issued. The principle underlying the distinction between the rule of res judicata and a rejection on the ground that no new facts have been adduced to justify a different order is vital. If the principle of res judicata is applicable to the decision on a particular issue of fact, even fresh facts were placed before the court, the bar would continue to operate and preclude a fresh investigation of the suit, whereas in the other case on proof of fresh facts, the court would be bound to take those into account and make an order comfortably to the facts freshly brought before the court. Emphasis is ours. Now para 14 is the crux of the case. Tested on the above conversed anvil, the present case, the order of IA number jitna, does not tantamount to a final adjudication of rights, nor it is one in respect of which the CPC has otherwise expressly provided. Here, my lord, I am telling. Nor it is CPC otherwise expressly provided a separate appellate remedy. In such circumstances, the scheme of Section 105 CPC clearly comes into operation, enabling the legal representative of Chandavar to assail the correctness of the said order in an appeal against the decree. To hold that such an order has assumed irrevocable finality would be to defeat the very purpose of Section 105. And to confer upon a non-appealable interlocutory status which the legislature has consciously chosen not to accord. Therefore, the contention that the dismissal of the application would oppress as a bar of res judicata, the issue is misconceived. Only to this extent, my lord, I am there. So, what my London friend says that the order was not taken in appeal, I mean in revision or in 227, that hardly makes any difference. Now, the point is, my lord, earlier application, as my learned friend rightly said, it was to include my name in the list of witnesses. Court declined. In the next application, I did not ask to include my name in list of witnesses. I simply say that I may be allowed to examine the witness of Ram Gopal Agrawal. I did not seek any process of the court to procure the attendance. He says that we don't know whether Ram Gopal Agrawal will appear voluntarily or he has to be summoned by the court. I will suffer the consequence. If Ram Gopal Agrawal does not appear of his own and I need summon, court will deny because court will be bound by the earlier order. So far this case is concerned. So I simply said, my reasons may be different, my lord. I just projected that why I need Ram Gopal to be examined because Hari Kishan, his brother, who could be a good witness, he died. And this is a very natural phenomenon in the family dispute, my lord. There are disputes about the family pedigree, how the property came to Susila Agrawal, the present plaintiff. These are the issues to be addressed. She has deposed. Now Ram Gopal Agrawal, being a family member to all these efforts, he could have said, this could have been by the Hari Kishan Agrawal, Ram Gopal Agrawal's brother. He died. So I said that I want to examine him. My lord, it is an order so innocuous. Lordship rightly observed that where was the occasion to court for the allowing such application? Court has said that yes, you can bring the witness of your own. Why you need my permission? Court has said so. Court has said so that you don't need my permission. You bring the witness.
Even if we allow this revision, that situation will remain.
My lord.
So far as 1A is concerned.
No. But my lord, this if the court allows the revision.
Supposing if this your objection in this revision application is rejected, we allow this revision.
That my lord will not, my lord.
That same situation,
let me complete my argument.
That situation will still remain. That will be
my
still
lord, it is there. What the court said, court having noticed the entire 16, order 16 to 1A. My lord, order 16, why that is very important for order 16, that list of witness to be given. 16 will deals with the list of witness.
Now,
2, 3, 4, 5.
Just tell us, for entertaining an application under sub-rule 3, where is the requirement of referring to 1A?
My lord, sorry.
Where it is contemplated, the 1A, provision of 1A becomes vital. I think like which way? What entertaining, admittedly your application was under sub-rule 3.
My Lord, I may just show one judgment of the Supreme Court, my Lord, where the Honorable Supreme Court has said that any non-mentioning, wrong mentioning of the sections.
Okay.
I will cite one judgment, my Lord.
Okay, that is okay. That we know. That's
And I think there is judgment of Meghalaya High Court very recently given in one case. Relying upon those judgments, my management will agree with that.
It's all right.
Meghalaya High Court judgment is there. Supreme Court judgments are plethora. That if there is a wrong mentioning, non-mentioning. Now, my Lord, I will read the judgment for the purpose. If the order is just and proper, without proper application of law, the order will survive, not the law. My Lord, I will read one judgment of the Apex Court. My Lord, may kindly see this 2000. No. My Lord, may kindly see. Palani Swami, it is 2009 AIR. AIR 5385.
AIR SCW, isn't it?
SCW, my Lord. So I don't read the head note because I don't rely upon the head notes.
Yes.
Lordship may kindly come to para 13. Para 13.
Yes.
A contention has been raised by the applicant, filed by the appellant herein, having regard to the decision of Madras High Court, could not have been ever entertained, which were filed under Section 148 of the Code. Section 140 of the Code is a general provision of Section 149, therefore is special. The first application should have been filed in terms of Section 149 of the Code, once the Court granted time for possible to extend the same by the Court in exercise of power under 148 of the Code, only because a wrong provision was mentioned in the appellant. The same, in our opinion, by itself would not be a ground to hold that the application was not maintainable and that the order passed thereon would be a nullity. Now, Lordship may kindly see another judgment.
Now just tell us, say supposing if you accepted contention and you said the wrong provision of law has been quoted in the application. What would have been the proper section? What would have been the correct section?
Correct section ought to have been Section 151. Now, I have read with Section 151, I have said, correct section would have been better than not 3A, 1A. Lordship rightly observes that 1A could be a better provision.
Now, 1A, you do not require any application.
My Lord, so I said, my Lord,
is there any requirement of what?
That is the court said that you don't require an application. Still the court says all right.
So that is why this court is telling you, says even if this order is sustained, if this order is stayed, 1A remains.
That remains. But my Lord, with the limited jurisdiction.
The court is not required to pass any order.
My Lord, with the limited jurisdiction of this Honorable Court in 227, as held recently by 2026 Supreme Court, Court will not make an issue out of a legal question if primarily the order passed is just and proper. Only will not go on the technical issues, my Lord. Even in 226 jurisdiction will not go. If you make out a legal ground and the outcome is right, there is no point in going in that. That will create misconception, misconstruction and misleading the court below, my Lord. Because every word of this court will survive over the court below. They will not dare to make any distinction on that, my Lord. Whole problem is there. I will cite one more judgment, my Lord, of Justice Ramaswamy on 16.1. It is 95 Supreme Court 244. So these all three judgments are on that point, my Lord, including Meghalaya High Court about wrong mentioning or Supreme Court even says that with the wrong mentioning, even the court puts the wrong provisions of law, but ultimately the order is just and proper. Court will not go into that issue. And similar to the judgment of Mangeram, as my learned friend referred 83.1, The same judgment is
That was the
95-4.
judgment referred by you, I think, that before the.
Yes, my lord, he referred, and fortunately he could not make out a point otherwise there, what the court below said. Very clear is that 1A is independent provision. Lordship rightly put a question that why 1.3 is there then, and that is already dealt with by the Mangaram judgment itself in para 10, as I said, that these are two different situations. My lord, suppose tomorrow what happens? I am coming with Ram Gopal Agrawal as a witness of my own because I don't need. Now he says, he subsequently, earlier he was ready, on the date when I said that please accompany to the court, he denies. In that situation, 1.3 will apply. I will request the court that he, though agreed, he is not coming, court may kindly, 1.3 is in both the situations. So that situation will arise only he does not appear. I need not say him other side that he said that I don't know whether he will be appearing of his own or not. That is not your burden, sir. It is my burden. If my witness does not come, I will fail. You will not fail. You enjoy the situation. So in this case, my lord, this is 95-4 SCC 244. My lord, may kindly see para 3 and 4. Except Mangaram case. Except by Justice Ramaswamy. My lord, I read para 3. Lordship got it, my lord?
Lalita.
Lalita.
Para 3.
Para 3.
Yes.
Order 16 Rule 1 and 1A adumbrate that the witness of the trial court are to be produced for examination by the parties by filing the list, and omission thereof prohibits them to avail the assistance of the court to secure their attendance, to give evidence, or to produce documents on their behalf. It is true that the legislature amended 16.1 and added Rule 1A to see that the undue delay should not be caused in the trial of the suit by filing the list of witness or the documents at belated stage. Thereby it envisages that on or before the date fixed by the court for settlement of issues, and not later than 15 days after the date on which the issues were settled, the parties are to file the list of such witnesses whom they propose to call either to give evidence or to produce document, and they are required to obtain summonses to such witnesses and for their attendance in the court. On failure to do same, Rule 1A says that they may without assistance of the court bring witnesses to give evidence or to produce document. In other words, if they fail to obtain the summons to the court for attendance of witness, they are at liberty to have the witness brought without the assistance of the court. It would thus be seen that the legislature did not put a total prohibition on the party to produce the witnesses or the production of the document. Nonetheless, when they seek the assistance of the court, they are enjoined to give reasons as to why they have not filed the application within the time prescribed. That's what prevailed with the earlier judgment. Court says that it was in 2018 you have filed the list of witnesses. At that stage also you could have filed. Now after 7 years or 6 years, you are asking, we are not granting. So what Ramaswamy also says that I have, now my lord, in the earlier judgment of 83, Supreme Court has clearly said, if the suit is already posted for evidence of the plaintiff or the party, if the evidence of the plaintiff is closed, then this provision will not apply.
But that is okay. We are not going to this thing. That is not the case here.
No. The point is
their case also. That evidence has been closed.
No. It is evidence is already fixed for 15/7 now. Before the court below, next date is 15/7.
That is okay. So
on that day, my lord, Lordship may kindly record my submission. I will examine only one witness. Though list of witnesses are so many, I will examine only one witness because plaintiff has been examined. I will examine only Ram Gopal Agrawal of my own. If I do not, I should close my evidence. What is the problem?
That is not for this court to do.
Yes. So my submission.
We are exercising revisional jurisdiction. We are confined to the legality and correctness of the impeachment order.
Legality and correctness. Legality and correctness subject to severe perversity in the order. If there is a perversity in the order, my lord, I will read one judgment of the Apex Court 2026.
We do not need, for those things, we do not need any decision.
Well, just Lordship may kindly keep it. If time permits, Lordship may kindly go through. Otherwise, the law is so clear about. So I will just read one paragraph, my lord, and it is 2000.
Judgment after judgment.
I must say that I never argue irrelevant. I never cite any judgment which is not relevant to the fact. Now, my lord may kindly see point 1 after para 30. para 30.1, exercise of power of High Court under Article 227.
Yes.
Lordship got, my lord?
Yes.
Before adverting to the factual matrix, it would be opposite to examine whether High Court exceeded the judicial vested
Just a
under.
minute. You are reading page?
It's page 10 out of 15. At bottom, the page number is there. Now, point number 1, specifically framed by the court was exercise of the power by High Court under Article 227.
Yes.
Before adverting to the factual, it would be opposite to examine whether the High Court exceeded the jurisdiction vested in it under 227 of the Constitution of India. The scope and ambit of the power of the High Court has been subject matter of consideration before those in several judgments, and the law governing the exercise of such power now stands well settled. In exercise of the supervisory jurisdiction, the High Court cannot act as an appellate court, nor can it sit in appeal over the correctness of the order passed by the courts and tribunal over which exercise the power of superintendence under Article 227. Yes. So, my lord, it is a very big judgment, about 10, 13 paras are there, all previous judgments are referred to. My only submission is, my lord.
This court knows the difference between an appeal and revision very well.
Yes. No, sir, I cannot dispute, I cannot dare to dispute. Point is only, my lord, that what the court says, now please come to the order, impugned order. Court dealt with, it is not that still the court took the point of res judicata, that it is not exactly res judicata, but the earlier order was passed, I cannot rebuild that order. Court has accorded it very clearly in the present impugned order, very clearly. All his arguments have been dealt with, though, my lord, it is not a principle of res judicata that applies in the interlocutory application, it is the order of finality. Finality is one thing, res judicata is another thing. Finality on one score or the other, interlocutory orders are there. That somehow prohibits or precludes the court from passing order on the same unless there is a change in situation. So I said there was a change of situation because in the meantime he died. And Supreme Court also says when there is a change of situation, even the finality will not apply. That court dealt with. Now the question is, Lordship may kindly see the impugned order. Court is, what I could get, that court is little concerned that what was the necessity for the court to pass such order. If you could have brought the witness out of your own on the next date of evidence, which is still there, so what was the necessity for passing? The court observed similar, my lord. Court observed similar. To avoid any ambiguity, tomorrow again the question may come that earlier order was this and that. Court says, all right, I permit you to examine the witness under the law. Court did not exercise any power as such. My lord, kindly see the order. It's very clear order. And I must say, my lord, this order from the Mofussil court is really appreciable. He has dealt with every aspect of the matter. Lordship may kindly see the order, the judgment of Manex, that has been so meticulously dealt with. 1A has been so meticulously dealt with. And finally, what he says, my lord may kindly see. I will not take the time of the Honorable Court. I will read para 19A. That also is not very much important. A conjoint reading of Rule 1A, in light of the decision of the Honorable, it clearly transpires that the obligation to supply. My lord may kindly see, in my application my learned friend did, I never asked for any summon. Lordship will notice that I never asked the court to issue summon to the witness. Had I asked the court to issue summon to the witness, then the matter is otherwise, because unless the list of witnesses is there, the court could not. I never asked that please give me a summon or please call the witness by a summon. I simply asked for permission. That was a very innocuous prayer. It could not have been made. It could have been made, and court simply to make the record straight, directed that yes, you can examine the witness in view of the law prevailing. No factual aspect has been considered by the court. In the suit in hand, the trial of the suit as a stage of evidence by the plaintiff. So one point is very clear, it is at the stage of plaintiff evidence. It is not that plaintiff evidence has to be reopened, it is at the plaintiff evidence.
These are not disputed.
Now, and the evidence by the plaintiff is not closed. Further, this court is of opinion that where the bar on furnishing list of witnesses under ITNA is for those witnesses whose assistance of the court is required for the purpose of securing their attendance. Therefore, where assistance of the court is not required for the purpose of securing their attendance, Rule 1A of ITNA of the Code of Civil Procedure Code would be applicable. Further, considering that the evidence of the plaintiff witness is not closed. And in the interest of justice for the purpose of proper adjudication of the instant suit, this court is of the opinion that the plaintiff be allowed to adduce. Here the court could have written otherwise. That since no summons is required, no list of witnesses is required, he is authorized under the law to examine the witness of his own. But the court granted a liberty. Court did not allow my application. My lord may kindly see the last order. Court did not allow. Court disposed of my application with this observation. It was simple observation of the court, observation on the law. My lord, judgment writing is a way one can write, we understand always. It says, proper adjudication of this court is of opinion that plaintiff be allowed to adduce Ram Gopal Agarwal as an additional witness. Court did not say that his name may be included in the list of witnesses. He may be summoned because prayer was not otherwise. And finally the court says, prayer of the land counsel but the plaintiff is adduce the evidence of Jitna as additional plaintiff is allowed, misdemeanor is also stand disposed of. So this allowing the application, my lord, per se was not an order in that sense whereby the court excises jurisdiction. Court only said that this can be excised. This is one way of the court, my lord, dealing with the situation. And rightly so, because he thought that earlier order may again come. If he goes of his own before the court, court will say, no, earlier order is there, you are precluded from examining. So court said, all right.
Your contention is otherwise, though application,
my lord,
was filed by quoting sub-rule 3. Essentially, it was not considered as an application under sub-rule 3.
Yes, it was not. It was, my lord, I must say.
And the court has basically only reasserted the right of the party under 1.
Under 1.
That is
and 1A is so clear.
Substance of your submission.
My lord, lordship, one question was there. What is, and I also read this provision thrice. Why then 1.3 and why then 1A? Ultimately, I found that it is there.
Not an expert in civil matters, sir. Whatever we get from the bar.
Sir, that is all. Whatever we get from the Honorable Apex Court or from this court, I have relied upon Meghalaya judgment also.
There is a contribution of the bar.
It is all we are learning, my lord. With 50 years of practice, I am still learning.
Anyway, so that is the sum and substance of your
my lord,
argument is that basically it is nothing. It is affirmation of the right of the party under 1.
My submission is, my learned friend also very fairly he said everything, my lord. That was the best part of his argument.
No, we know him to be a very fair counsel.
Because
we expect all others to be
at many stages he says the law is well settled. 1A also he said. I pointed out para 10, but he was there already. So, my lord, my submission is we should be fair before the court while arguing the case. Cases will come and go. We will be here. Institution will be here. And our duty is to learn. And
that is okay. So,
I must say,
Mr. Sen, that is sum and substance of the senior counsel is that.
Yes, I will try to distinguish.
Reaffirmation.
Correct, I understand. Allow me some time to distinguish. Yes. I'm very grateful.
Let us not go to any other thing. Just remain confined to the point.
Correct.
Because
you're also going to confine to that last part.
The court will not understand. So,
no, I've learned something very interesting here from my learned senior. I am very obliged. But allow me to just address these points. Management may not accept these points. Yes. First of all, there is this whole issue of 105. I don't know where this will travel. It may become an issue subsequently. In my humble submission, my lord, 105 and that judgment that my learned senior has referred to will have no application in this case. Let me just point out what is the issue with this 105 judgment. The judgment that my learned senior referred to, the first one, Palaniswamy, if I'm not wrong. Where is the judgment of 105?
Parvatava, oh no, Chanappa. What is that?
P.K. Palaniswamy. No?
Chinappa, is it?
Chanappa. Is it Chanappa?
Right, my lord, sir.
105.
The judgment of Justice Dipankar Datta.
Yes.
Correct. The first one, 2026.
This is Chanappa. Chanappa,
yes,
isn't it?
Yes. Chanappa, the facts from what I understand, there was a particular issue which was rejected and no revision or appeal was filed because revision is precluded under the rules. It is not appealable under Order 43 Rule 1, but nonetheless no revision was filed. Subsequently, that order came to be challenged in the final statutory first appeal that was filed. And this particular order, which is an interim, which was passed at some point in the interim during the pendency of the suit, also came to be challenged along with the final judgment and decree. The respondents there raised an objection that you can't challenge this particular order because you've lost the bus. You've missed the bus. They should have been challenged at the appropriate time, but having not challenged it, you can't challenge it. So they referred to 105 and said that has not attained finality because it was interlocutory in nature. And therefore, it did not decide any of my rights, and it is assailable under 105. No dispute. Please look at the facts of this case and what was the actual order which was challenged. There, the court held that this was interlocutory in nature and assailable under 105. In our case, the order which they suffered disallowed them from bringing that witness on record. In my humble submission, it decided a particular right. Now, was this assailed under 105? No, because we've not reached the stage of 105. They subsequently undid that particular order.
105,
my lord,
will remain even
correct.
After this order.
Correct. Now
So
that's
105 is not a very vital.
that's what I'm saying. In 105, as far as 105 is concerned, we are not concerned with it because we are not at that stage at all. That order was never challenged under 105 because we never reached the stage of 105. My case is that that particular order which they suffered, the first order rejecting the witness, attained finality. By referring to this judgment of 105 and referring to certain passages, in light of that specific order, my learned senior is making the case that this particular order has also not attained finality. These are two different set of orders. Let us not say both the orders are at parity. Number one. Yes. So, most importantly, that order could not have attained finality because they revisited that by filing a fresh application, undoing the same order. And this time they secured a favorable order. So to say that the order never attained finality, that is only in light of 105. Completely different set of facts. So I don't think we need to look at that particular judgment or the provisions of 105. In my humble submission, that order did attain finality because it was never challenged. And you again filed an application to undo that particular order. So the principles of res judicata definitely apply in this particular case. The second point, my lord, is that in either way we look at it, this was a case of quoting of a wrong provision of law.
Please take your seat. Yes, this is okay. You do not have to stand up. Let him say.
My learned senior has also indicated that we should not be very strict with the nomenclature of the petition, the court's title, treat it as an application under 1A, and also gone to the extent of saying that the court also did the same thing. In my humble submission, I don't see it that way. The reason is this. Please look at the first application. It is not a case of simplicity or wrong mentioning of a provision. It is not.
The wrong mention is in the second application, not in the first application.
No, second application itself. Please, it's not a case of a simplicity or wrong mentioning of a provision. Please look at that provision read in totality. Holistically, if you read the petition, my lords will find that they are asking for substitution of a particular deceased witness. And they indicate all the facts truthfully, and they say so-and-so witness is expired. Inadvertently, I could not bring his name in the first round. It was dismissed. Now so-and-so is expired. Please bring in my name. Please cause a substitution, replacement. These are the words that they use. And what is their actual prayer? Ultimately, courts will decide the jurisdiction and the correct nomenclature based on the prayer, my lord. Please see the prayer at page 77. This is what it says. By replacing the witness in place of Hari Krishna Agarwal. How do we ignore this particular prayer? Ultimately,
that
the
is
court
what
will...
has been, see, the senior counsel here has said
yes,
that the court has consciously not allowed the petition.
No, that's also incorrect, my lord. I'll show your lordship.
So what is basically is nothing. It is a reaffirmation of right under 1A, nothing else.
My lord, please directly come to the last part of the order, of the impugned order, which my learned senior has been pleased to refer to. My learned has now said that that particular application has not been allowed. Please see page 20, para 21.
Yes.
I'm a little surprised. Para 21, my lord. Prayer of the learned counsel for the plaintiff petitioner.
Some mistakes will be there on the part of the senior also.
No, I don't say that, sir. I don't say that, sir. No, I don't say that. Please see this. Prayer of the learned counsel of the plaintiff petitioner to adduce the evidence of the witness is allowed. How can we say that the prayer was not allowed? And therefore the court goes on to say case stands disposed of. Now, we shouldn't be so strict with the court to say court did not use the word petition is allowed. It's disposed of and says prayer is allowed. Which prayer? The prayer in the second application. And therefore I'm saying, my lords, the stated position of law is courts don't go by the nomenclature assigned in the cause title. Courts go by the substance of the petition and evidently and ultimately by the prayer. So let us look at the prayer. Replace so-and-so, cause substitution. That is their prayer. So where is the provision of law? By looking at the petition holistically, you can't ascribe 1A to this particular case. That's my humble submission, my lord. Now, please also see one additional thing. My learned senior has said that the court has taken note of the plea of res judicata. My lords, I have gone through this order more than once. I have not found the court adverting to my plea of res judicata even once. If that was the case, court would have consciously taken into consideration the three principles of res judicata and decided on that point, would have said that the parties are not the same, the field of controversy is not the same, or that this particular order is not binding. What is happening today, my lord, ideally in a revision application, court has to look at the perversity on the part of the order, whether there is a failure to exercise jurisdiction or wrong exercise jurisdiction. Now in this case,
Jurisdictional error.
these
more or
are
less,
supplementary submissions being made in aid of this particular order. These reasons are not assigned in this order. My lord, say, am I being fair? Will lordships find those reasonings? These are advanced by my learned senior in the arguments. Where are these present in the order? What my learned senior is saying, please infer this. This is what the court wanted to say, perhaps wanted to say, desired to say. It's not in the order. My lords, are a court of record.
Principle of equity.
Lordship, and now asking for equity. So my lords will go by the record, I would say. Please go by the records and see, is this present in the order? Did the court look into my application or look into my plea of res judicata? No. Not once has she looked into the question of res judicata.
To what extent we will be bound by technicalities so far as summoning of witness is concerned, if court finds otherwise that evidence of that person would be
My lord.
vital for proper adjudication of the matter.
My lord, this will set a precedent for the same court for all the other courts. If we say that this is the correct course of action, that you first file an application under sub-rule 3 and say that my application is dismissed, we'll ignore res judicata completely. This is a substantial point of law affecting my rights as well during the course of the trial. And you allow the party to file a similar application, same prayer, and also allow them to say that you can replace a witness, you can substitute a witness. These kind of foreign issues are allowed. This will set a very dangerous precedent. So I would submit, set it aside. This order needs to be set aside, and then they have their recourse to 1A. What stops them? They do have the recourse to 1A. They can bring that witness. And if I do have a right in accordance with law, I'll raise that objection. If I have any objection at that point. But not in this manner, my lord. We can't read into the judgment, say court wanted to say this, court desired to say this, we should read this reasoning in the order. That's not correct, in my humble submission, my lord.
Now, so far as the contention of the senior counsel here,
My lord.
that there is a wrong quotation.
Yes.
The thing that was never been.
No. Never. Not once have they said that.
First time here.
First time, and also, as I'm saying, I don't have that judgment with me right now. Courts do say, don't look at the nomenclature, but look at the entire petition holistically. And you will derive your jurisdiction based on the prayer.
Substance
the
and
prayer
prayer.
clause is important. And look at the substance of the petition. Do they say even once that he is within my control? What do they say? So-and-so has expired, I want to cause a substitution.
Now they are saying.
No, even in their petition, in the second petition, they say I want to cause a substitution and a replacement.
No, but then now, before this court, now they are saying.
Court may record my
That's a different thing, my lord. That's a different thing. But then, that's what I'm saying. For the purpose of a precedent, for not setting a wrong precedent, my lords will at least have to set aside this
summon
order.
for my husband, my lord. To what extent he will support my case? Lordship may kindly see.
My lords may not recall.
He is my husband, and if I need to summon him for a witness, Lordship can understand what type of witness
It could be an
I will
estranged husband.
That
For
was
what do
the
we know?
effort which you had given at the first time.
My lord?
The first time, you wanted him to summon, isn't it?
No. There was no prayer, my lord.
Application which
No,
was
there was
rejected.
no prayer to summon. Last time also,
Oh, yes, you said it.
court has written that to call the witness, but there was no prayer in the first application also to call the witness. At two places in the concluding part of the order, earlier order, the court has said that they have asked to call the witnesses. There was no prayer to call the witness. I did not go because that order at this stage we cannot. Because I have not challenged that order. This is subject to again 105 and other things. So I have not gone. Lordship may kindly see the earlier order that the prayer is to recall the witness. To call the witness. There is no prayer in my application to call the witness. Lordship may kindly see at two places the court has used it.
I'll conclude with another very interesting point, my lord. Now, this has to do with something passed in the order and as well as one judgment which was in place by my learned senior. Please look at the judgment of Lalita Rai, 1995, 4 SCC 244.
Yes.
Now, Lordships have seen Order 16.1 states that a list of witnesses has to be filed within 15 days of settlement of the issues. So time is prescribed. Here the Honorable Supreme Court says we shouldn't be so strict about the time. And what it says is that witnesses may be brought for reduction of evidence. Now this judgment is from 1995. Please note this is a very relevant issue. Order 18 came to be amended in 2002, mandating filing of evidence of witnesses via an affidavit. Prior to that, a witness would be brought, placed in the dock, and his examination would be conducted. 2002, Order 18 was amended, and now as it stands is that it is mandatory for the witnesses who are within your control to file affidavit of examination in chief. So to that extent, this judgment we should not look at because it does not consider Order 18. Now, I'll tell your Lordships why this is relevant. Please look at the last part of this operative part of the order, page 20. What the court allows.
Of the impugn order.
Yes. PC para 20, towards the end.
Yes.
This court of the opinion that the plaintiff be allowed to adduce the evidence of Sri Ram Gopal Agarwal as additional witness in the instant case, ignoring something very vital, ignoring their own previous application. Now please look at the previous application at page 56. In fact, even I was not aware of this. They pointed this out to the court at the stage of hearing at some point.
So in
Please see
rejoinder,
page
my lord,
56.
in rejoinder we have experience that you cannot address a whole case to restart with. You can only address the points if I have argued something.
I'll leave it to your courts to allow me to either submit or not.
He will argue again.
Please.
My lord, so what your Lordships will find, because this is in response to this judgment, there's something very
Yes, yes,
material.
go ahead.
So what the court allows, this is also a perversity on the part of the court, with great respect, that adduction of evidence of the witness is allowed. Now please see page 56. This is their first application that they filed, para 3. That the plaintiff filed deposition of all the witnesses and in doing so later realized that due to bona fide mistake on the part of the conducting counsel, the list of witness proposed to be filed was inadvertently replaced with another list, and in doing so the name of Ram Gopal Agarwal has been left out. However, the deposition on affidavit of the said witness has already been filed along with a copy of the defendant. Apparently, they claim that they've already filed the evidence, examination chief, in view of Order 18, already filed, despite his name not being mentioned in the list. Now the court ignores that and says, what does the court allow? Evidence. That is examination in chief, which they claim is already on record. So now in any event,
Was there an affidavit filed in matter?
Yes.
Effect?
evidence was filed. So if it was filed, he'll be allowed to be introduced as an additional witness and have to cross-examine him. Not that his evidence is going to be adduced anymore. His evidence is already on record, apparently. But this is at a stage where they had inadvertently placed his evidence without there being anything on record in that particular list, his name being featured in the list. Now, in conclusion,
this makes things more complicated then.
My lord?
Is it not that then thereafter, if any affidavit is filed,
Yes.
that would mean that the witness was definitely under their control?
That was the intention, within their control. They filed multiple, which is what I'm saying, is this applications.
Where's the need of,
No need at all.
invocation of Sub-Rule 3?
No need at all. They have not been able to understand. I'm not attributing this to my learned senior. At that stage, they did not, either they were not aware of Mangeram or did not read Mangeram properly. They were not clearly understood of the provisions of 1A. Which is why, apparently, without the name being featured in the list, they filed the evidence. Then they filed an application.
Now it means like you are trying to say that even if
My lord.
the court wanted to allow their prayer, could not have been for the examination in chief because this is already there in there.
We will not go for examination in chief, my lord.
So, which is what I'm saying, there is perversity in the order.
We will not go
There
for
is perversity in the order.
We cannot.
This ignores their own previous applications.
But then this is the part, it was not pointed out to the court earlier, this filing of the affidavit by the witness.
Lordship, that's what.
The court has
It's-
recorded in the order.
In the order, it's there.
Yes, order is
And
recorded.
interestingly, so then therefore there was no need for this order. That is what I'm saying. Court cannot say I'm allowing your prayer for replacement, substitution, etc. So therefore it is perverse.
Substitution is not allowed by the court.
No, but then, is it not that all those, contradictions or inconsistencies can be avoided?
No, that's what I'm saying, my lord.
And then by simply
Today,
allowing the witness to be
today on the
cross-examined.
advice of my learned senior, good senses prevailed. They realize yes, 1A is available to them, and they should be before the
I will
court.
come to the trial court also, don't worry.
I don't stop
Because
there.
it is my sister's case, my lord, I am to be
I
there.
understand that. Now, so given this position, I'm saying this particular order clearly suffers from several perversities.
But that is okay. But then you can understand.
Raised
Lordship.
issue.
And so,
But then, if this witness is cross-examined now,
Lordship.
what would be the problem?
No, I'm not saying there's any problem.
We'll say that those whatever finding recorded would not create any precedents.
Yes.
Then kindly set this aside. This will otherwise create a precedent. This has to go, this particular order.
Let the court decide.
Why do they want to? Well, let me address.
Why should we put in the mind of the court?
Anyway, my lord, what I'm saying,
Court is already
without
approving
being interrupted by my learned senior, with great respect, my lords, what we are here for is to decide whether this order, as it stands, suffers from any perversity or not, given the special facts of this case. What your lordships will find, the court has ignored my submissions. A very important plea of res judicata has been completely ignored, and an order has been passed, the end of which makes no real sense. If the court was aware that the evidence of that particular witness is already on record, by rejecting the previous application and by them not having done anything for more than a year, they didn't want to bring that witness on record. They didn't want the witness to be cross-examined. They didn't want to take recourse to 1A. That is what the point I'm trying to make. Now, after 14 months, they file another application, identical in nature, and they say, we want to bring this witness on record. Not with recourse to 1A, but by saying that this probably is not within my control. And let's not go into this whole issue, he's my husband, he's my son. That's not the issue. It could be an estranged
That
son.
is that the court will not be guided by those emotional things. That is what she.
Yes, precisely. So we go by the records. Does the record indicate, do their applications indicate that he's within my control or not within my control? Doesn't say anything. Nowhere in the order is it reflected that they've made some supplementary oral submissions.
Forget what they are saying. Even the court's order also that.
Yes, it does not say that. I can't argue in this manner if I'm going to be stopped because they have a flight.
I am to reach airport.
How do I argue a matter like this?
Okay, we'll close it. We'll just keep it for orders. We'll just see what happens. We'll just see if possible. Do not know if time will permit today or not, because we'll have DB and
Lordship, may I take on? Well, my only request is, if that appeals to the court, that since the matter is pending 2017, and our Meghalaya rules provides that within 5 years, may I request a expeditious disposal of the case?
Let us see. Let us first
It is on
dispose
the ground of
this.
bona fide requirement.
Let us first court expeditiously dispose this matter. Then we'll thinking about expeditious disposal of other things.
Much obliged, madam. Deeply obliged for giving a patience hearing, madam.
Well, is you reserving this for judgment?
Let us see.
We'll see if we'll see today.
My lord.
Or otherwise it will be resolved. If time
Obliged.
permits today, we'll try to first orders today or otherwise.
As much.
Obliged.
Obliged, madam. Much obliged. नहीं, नहीं,
Very costless. Hearing item number 10.